Right, well, welcome to Lecture 4, Topic 4, Week 4 in LWZ 304 Administrative Law for Semester 1, 2017. Hopefully you can see the PowerPoint up there on the whiteboard. And as you can see, this is the fourth and last of our weeks or topics about administrative law merits review. And today we're going to be looking at freedom of information. Next week, of course, we go on to judicial review, and we spend the rest of the semester dealing with judicial review. So we've got basically, 4 weeks on merits review and then 8 weeks on judicial review. The chapters of Crike and Macmillan and Head, respectively, are listed there on the PowerPoint, and of course they're in the study guide as well. The study guide, again, is pretty comprehensive. It runs to 17 pages, and it's relatively up to date. It certainly encompasses the 2010 amendments to the Freedom of Information Act, the Federal Freedom of Information Act. Well, why is this saying stop pause? I don't want to stop pause. I'll get rid of that. The notes or the study guide are firmly based in the Federal Freedom of Information Act rather than either the Territory one or any of the state models. But it does encompass the fairly major amendments that were made to the Federal Freedom of Information Act in or about 2010. There hasn't been much in the way of amendments since then, although there were attempts by the Abbott Liberal government to abolish the office of the Information Commissioner as part of the savings they tried to make in the 2014 federal budget, but it was among the many amendments that didn't get through the Senate, so they weren't able to abolish the Office of Information Commissioner. However, what they proceeded to do was to completely defund the Office of the Information Commissioner, and so poor old John Macmillan, who is indeed the author of our textbook, but also was at the time the Federal Information Commissioner, he was actually left with no staff whatsoever to run the Office of the Information Commissioner, which had become quite central to the operations of the Federal FOI Act under the 2010 amendments, to the extent where poor old Professor Macmillan ended up running the Information Commissioner's office from the spare bedroom at his house. Which is a bit extreme, you'd think, wouldn't you? But anyway, he eventually gave up and resigned, but fortunately at around about the same time as he did give up and resign, Malcolm Turnbull rolled Abbott as Prime Minister, and thankfully one of the first things he did was to back off on abolishing the Office of the Information Commissioner and at least largely, although not entirely, refund it. So and it was one of many stupid things that Mr. Abbott did, frankly, that luckily Turnbull has reversed. My personal private political view is that Turnbull actually isn't a bad Prime Minister, certainly by comparison with Abbott, and that he doesn't get much credit for quite a few significant things that he's done that have reversed the idiocy of Abbott's reign. I mean, in my view, and again, completely personal, private political view, which in no sense reflects the views of my employer, Charles Darwin University, Abbott, in my view, is probably the worst Prime Minister Australia has ever had, bar none. And anybody who even thinks about the possibility of him coming back needs their head read. He was profoundly destructive of the Australian political system in all sorts of ways, and freedom of information was just one of them, although one that in my view is more important than most of the political journalists realise. No, well, I'm sure a lot of people didn't vote for him, but a lot did. Anyway, carry. Well, I accept that Rudd wasn't all that flash either. I do accept that. But Abbott was, I think, a country mile worse. Let's move on to our first point here. One thing this is a general point that I make that's equally applicable to all of the merits review topics and, for that matter, to the federal statutory judicial review under the ADJR Act as well. It's important to note that in public law, there is no right to reasons for decision at common law. At one stage, Justice Kirby, as he once was, when he was president of the New South Wales Court of Appeal, as opposed to a High Court justice, attempted to slip in a right to reasons at common law as an aspect of natural justice. And he got away with it for a few years until the case Public Service Board and Osmond got to the High Court, and the then High Court majority squashed it from a great height and said, no, there is no right to reasons for decision at common law unless such a right is provided by statute. It doesn't exist, which is a bit of a shame, really, but because, I mean, in a practical sense, it's hard to see how one can get substantive or, for that matter, procedural justice if you don't have to be told why a decision has been made against you. They just have to, if the department or agency or public servant or minister just has to say, well, you know, too bad, so sad, you lose, application dismissed, but we're not going to tell you why. I mean, it's quite extraordinary, really, isn't it? But that's what the High Court found, so one has to live with it. But fortunately, one of the numerous good things about, you know, Sir John Kerr's new administrative law package, as it was called when it actually was new, is that each of the four elements of it actually do contain a statutory right to reasons for decision. Now, by the way, just so we can reinforce this yet again on the last week of our coverage of merits review, what are the four elements of the new administrative law package that Sir John Kerr recommended and that successive governments implemented in the 1970s and early 1980s? What are the four elements? Ombudsman's one. What's number two? Freedom of information is two. What's three? The AAT is three, yes. And what's the fourth? No, not the cat things, because the cat things are like AAT. The fourth one is, what did you say? That's right, ADJR. So statutory judicial review of administrative decisions. Well, it's the Administrative Decisions Judicial Review Act, which is a statutory embodiment of the common law of judicial review. Now, basically, over the next 8 weeks, what we're going to be doing is covering the common law judicial review stuff, albeit that I think most, if not all, of the study guides contain cross-references to the relevant sections of the ADJR Act. So you'll have those cross-references, and then in week 11 or week 12, we focus on some specific aspects of the federal ADJR regime. But because what ADJR basically does is just to codify, in one sense, the common law of judicial review. It's good enough to cover the common law and then to look only in the last week at the way in which ADJR modifies it or improves it or whatever. In some ways, I might say, it's the way it's all been elucidated. It's actually worse in a couple of respects, but we'll have a look at that in week 12. But I mean, the thing is, because it codifies and modifies the common law, we really have to know what the common law says before we look at the way in which ADJR modifies it. So that's the way the course is structured. But the point is, for present purposes, that all four elements of the new administrative law package contain a statutory right to reasons for decision. So therefore, at least at federal level, you will pretty well always be able to force the decision maker to give written reasons for decision, despite Public Service Board and Osmond. So there might not be a right of common law, but it really no longer matters, at least at federal level. It probably also doesn't matter mostly at state level, because now every state and territory has at least Ombudsman and FOI and an AAT analogue like VCAT or NTCAT or whatever. And again, each one of those contains a statutory right to reasons for decision. Of course, the only thing is that as we looked at last week, Ombudsman legislation doesn't cover everything. And of course, AAT/NTCAT doesn't cover everything either. Not all. There's only a right to merits review under an AAT type body if the Individual Enabling Act says so. So there are some bodies that aren't reviewable under that. And at state level, at federal level, as we'll see when we get to it in week 12, ADJR is sort of the opposite side of the coin to AAT. AAT only provides merits review if a particular enabling act says so. So the default position is there ain't no merits review. Whereas under federal ADJR, the default position is that there is judicial review unless a particular act excludes it to some extent. So there always will be, unless the particular act says, no, you can't have it in this area. And typically what happens is that the acts that expressly excluded are intelligence-based ones, police, criminal intelligence and national security and those sorts of areas. But other than those sorts of areas, generally speaking, you've got a statutory right to judicial review and a corresponding statutory right to reasons for this decision. So at federal level, that more or less means you've nearly always got a right to reasons for decision, whereas at state and territory level, it may well be a bit patchy. There may be some times when you've got a right to reasons for decision. Usually you will, but there are more gaps at state level for the reasons that I've just given. Is that reasonably clear to everybody? Because it's actually fairly important, because if you read the notes on this, and for that matter the textbook, about what a proper set of reasons has to contain, it should become more apparent to you why it's actually quite important. And it will become even clearer once we start to do judicial review next week, because lots of the grounds of judicial review are going to be very difficult to prove unless you know what the reasons for decision were. For instance, the grounds of judicial review include that the decision was made for an improper purpose. Well, how are you going to prove that if you don't know what the purpose was, because they didn't have to give reasons for their decision? Another basis for judicial review is that the decision maker took into account irrelevant considerations or failed to take into account relevant ones that the Act required him to take into account. Well, again, how are you going to prove that if he doesn't have to give you reasons saying what he did take into account and what he didn't take into account? You can't really know. And as we're going to see as we go through it, there is a common law presumption of regularity in relation to administrative decision making. So it's not enough to say, this looks mighty, mighty suspicious, this mongrel didn't take into account these things. Because the judge's answer is going to be, well, it's up to you to prove that, Mr. Parrish. You can't just say you suspect it. You can't just gesture hypnotically and say it looks mighty, mighty suspicious that maybe they didn't take into account things. You have to be able to prove that they didn't. So the right to reasons for decision is extraordinarily important. So that's why this whole administrative law package, both at Commonwealth level and at state level, to the extent that it's been enacted at state territory level, is really important. If you don't have it, then your ability to effectively scrutinise and challenge administrative decisions that are adverse to your interests or the interests of your client is going to be quite severely restricted. Say that again? I don't really know. It's an image that I stole from somewhere without looking at it very, very carefully. I don't think it really matters very much. It's a person on a stick saying what, why and how. It's gender neutral, so it's probably quite politically correct, really. Freedom of information legislation, well, this slide sets out the purposes, so this is potentially important in terms of statutory interpretation. If there's ambiguity about the meaning of any particular provision in freedom of information legislation, you're entitled to gesture in the direction of the objects clause and say, well, it must be interpreted, Your Honour, in the context of the objects clause, and given that that object is positive and remedial, then if there's any ambiguity, it should, on ordinary principles of statutory interpretation, be interpreted generously in favour of access and not the other way around. However, as we're about to see, that's sort of not the way it worked out in the first decade or so of FOI, which is why there was the need for reasonably comprehensive amendments in 2010 that were under the benevolent guidance of Senator John Faulkner, who sadly retired soon thereafter. So, as the slide says, all states and territories now also have FOI legislation. The Northern Territory was the last in 2002. It was one of the early reforms enacted by the Labor government under Chief Minister Claire Martin, and you know, greatly to her credit that was done. And at the time, it was very much a pretty much state-of-the-art model. I mean, it's been sort of surpassed in some senses by the Faulkner reforms at federal level and by technological change, you know, the internet and so on, as we'll get to later in the lecture, because that's very much the focus of the essay which 50% of you are going to be doing, which I will be giving some sort of hints or guidance about as the lecture goes through. There's some variation of detail between states and territories and the Commonwealth model, but basically similar. Many state and territory models, including the NT one, now include an Office of Information Commissioner, which is sort of the key and most important reform enacted by the federal legislation that several states had already implemented, and fortunately Claire Martin adopted that model even before the Commonwealth. So we have got an Information Commissioner, which is a good thing, a positive thing, and neither party has seen fit to try to do what Abbott tried to do and abolish it or defund it. So we do have an Information Commissioner whose office is well funded and does their job reasonably effectively, given some of the other defects in FOI that we'll talk about. Access to policy. Now, this is actually quite important in terms of FOI. I won't take you to the actual section, the relevant sections of the Federal Act. There are similar provisions, I think, in the Territory Act, but sections 8 and 10 of the Federal FOI Act are the key here. There's an obligation on departments and agencies to publish and make available their policy guidelines that guide discretion in the making of administrative decisions. Now, you'll remember when we considered AAT a couple of weeks ago, that issue of policy is a very important one, because unavoidably pretty much every Act of Parliament must contain significant discretions. It just isn't possible to devise an Act of Parliament that can foresee every possible permutation and combination and nuance of circumstances that might arise in relation to any given area of government and to provide mechanical tick-the-box answers to every situation so that every administrator making every decision under every act is able to just look at the act and say, yes, 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 no, therefore application refused. There has to be discretion because there's almost infinite variation of circumstances between people and situations and times. And once you introduce discretion, then if you want that discretion to be exercised in a flexible but consistent way, then you have to have policy guidelines. Why might it be important for it to be consistent, do you think?
Is that a trick question?
No, it's not a trick question. Hang on, I'll hang around the thingy so that the people in the thingy can hear what you're saying.
Because people have different views, and so it'd be subjective, and that people would just make up what they want.
Yeah, that's one thing. Yeah, yeah, and that would be unfair, I suppose, wouldn't it? I'll see whether I need to answer this or just get it quickly and get rid of it. Hello, Ken Parrish speaking. Yes. Now, sorry. What were you saying? Were you saying something before? Did you say something already?
No.
You didn't. Okay. Well, do you want to say what you were going to say?
So it's merits review. So everyone's merits would be different. So the only thing that would be consistent would be the policy that applies to everyone. Because that's off the top.
So consistency, fairness, predictability, but also flexible. Yeah, because I mean situations differ. But there's another. It's gone red again. Oh, press the button again. Is it still green now? Oh, you turned it off, right? Oh, that's okay. Right, no worries. Yeah, the other. Well, anybody in the collaborate room want to add a little bit here? There's another little magic word or term that I was going to add. Will you pick your hand up? Yep, go on.
What's the magic word? Procedural.
Magic 2 words, but go on.
Procedural fair requires knowledge of a procedure.
Yes, that's another magic expression, not the one I was thinking of, but it's absolutely true. Yeah, I mean, if you don't know what, because apart from anything else, it's a relevant consideration. I mean, if they've taken into account policy in making the decision, then at least on judicial review, you would be entitled to access to it because it's relevant and discoverable, and they've taken it into account. So, absolutely. So it should be available anyway. One would have thought. So it's sensible to have a statute that creates a clear obligation to do so. Adrian Ross, yes.
Would it be also to increase public confidence in the system?
Yeah, that's another good practical reason as well. Yeah, so that it's not sort of secret justice, secret administrative justice. That in all but, I mean, there may well be sort of criminal intelligence, national security situations where there might be some aspects of their policy and guidelines that they don't want to make public for good reason. In most situations, there's not. But no, there's another concept that's worth bringing to mind here.
What's the first letter?
ROL. Not LOL, it's not laugh out loud. Rule of law, that's it. Yeah, the dicey concept, yeah. So, rule of law, yeah. ROL. Yeah, it's just rule of law. Yeah, I mean the elements of rule of law, of course, include consistency and non-arbitrariness, and also, of course, equality before the law. It all applies equally to everybody, and must be applied in a consistent, non-arbitrary manner. So that's why you need to have policy guidelines, so that where there is a discretion, it's not hit and miss, and it depends which public servant you get. because they all have an individual interpretation. There's policy guidelines to ensure a reasonable level of consistency, but also, as Sam said, a reasonable and necessary degree of flexibility. And of course, policy guidelines can be changed more quickly, changed and updated more quickly and easily than either legislation or regulation. So it's very important to have policy guidelines, and it's very important that they be published, and FOI legislation requires them to be. Moreover, Section 10, again I won't take you to it, Section 10 goes on to say that if they haven't published it, then you're not allowed to be disadvantaged by the application of it. So if had you known about it, you might have been able to conduct your case differently. It might have had a different outcome. But they haven't published it and made it available, then they can't make a decision that's adverse to you. So let's move on now. Stephanie, you made a comment about not hearing. Are you able to hear generally? Because we can't be perfect in terms of passing the microphone around the room. It's just human nature does not allow for that. But we're doing the best we can. Let's move on to the next slide. So that's policy. Access to documents. FOI creates a legally enforceable right of every person to obtain access to documents of agencies that are subject to the Act, provided that A, any applicable charge is paid and the request does not involve unreasonable diversion of the agency's resources, and the documents are not exempt. Now we'll go on in a minute to have a look at the exemption areas, but what about those little dot points, any applicable charge is paid and does not involve unreasonable diversion of the agency's resources? Now, there's a lot of nasty little things that are hidden behind those words. Does anybody know what they are? I bet you do, Matthew. Would you like to tell us about some of them from your experience? Would somebody like to pass the microphone to Matthew so he can tell us about what this requirement for paying applicable charges might mean in practice, and what allegedly unreasonable diversion of the agency's resources might mean in practice? What do they actually do?
On personal experience, having put in for a FOI request on my own information, typically if it's for your own information it costs nothing, but they've still got the right to actually charge you for use of agency resources to develop that. In my FOI request, I was waived those fees, even though they said I took up phenomenal amounts of resources. My request was through the AFP, and there's an AFP information commissioner who actually had to write me a nice letter saying, this is the stuff that I've given you, this is why it was redacted, and this is why I'm waiving the fees. So there was a whole range of that. Talking about inordinate delays, theoretically it's supposed to take 28 days by legislation. But I found on every 27th day they would write back to me requesting an extension because of the sheer volume of work they had to do. So it took, instead of taking 28 days, it actually took 4 months before I received any information. Yes.
The question was he asked to refine the scope, and the answer was yes.
Yeah, so first of all, the initial scope was just a general request of what information was had, then it was like, oh, that's just too much information, we'll never be able to get all that to you, that's like volumes and volumes of stuff. And so then it was, a request was put down, but that was another, we'll refine the request on the 27th day, and then we'll give us another 28 days to actually do your request. And then on the 27th, the second 27th day, they actually wrote back and said, we've got to consult with third parties before we can actually release your information. So then I had to get permission from the third parties to release the information. And then on the 27th day, again, they said, now we've had to take it to actually the state to actually talk to the Northern Territory. And we've got to get permission to release the information from them. And then eventually I got the results back of, I think it was about 20 odd pages, but 10 of them have been blanked out. So pretty much it was nothing that I didn't already know.
And this was personal information where you would expect you
yeah.
would be entitled to all of it, leaving aside national security things.
Yeah, and so there's large waves of the document that's just literally blacked out and says like section 37.
Yeah, so that would be in relation to exemptions rather than applicable charges and so on. Oh, hang on. We'll get to those later. Let's work. Yeah, no, but I want to conduct the lecture in a reasonably logical manner, and we haven't got to exemptions yet.
So, well,
Well, if he wants to talk about it, yes.
But one of the things was they were talking about the sort of volume and the unreasonableness of the resources that would be used just to do my one request. I thought it was pretty straightforward. I would have been happy to go in the office and just look at the file, but of course they wouldn't let me do that. I had to sort of go through a whole range of permissions before they could actually release the information.
Yep. Okay, beauty. That's great. Now, Amandeep.
I'm not sure if you can hear me.
Yes. Yes.
I can. I've got a similar experience with the. I'm not going to name the department, but it's to do with the health. Like, I put for my own personal information and under FOI, and I was told by the chief information person of that department that information does not exist, despite having all the information. And in the end, they just decided not, going to give it to you simple as it is. And I was reading the book today and could not believe it. What some of the charges they used to charge that News Corp Limited. I think at one stage they were quoted for 153,000 or something like that for a release of some documents. That's all I got to say.
Yeah. Okay. Look, thanks for that. So with both of you, there was a need for refining the scope of what you're asking for. Otherwise, they might well have taken the objection that it involved unreasonable diversion of the agency's resources. That is the Section 24 objection, and they might well have charged money for it, whereas in Matthew's case they waived charging. Now, that's relatively common where it's personal information that they will waive the charge. They're not obliged to, though. Again, it's discretionary.
And the thing was, if my legal team had actually contacted the office on my behalf, they would have been charged for it. But since I contacted the office on my own behalf, there was no charge. Right.
Oh, that's interesting. Yeah, that's a strange rationale, but and might be challenging because you wouldn't have thought it's a proper basis for exercising a discretion that will screw them and charge them money if they've got lawyers, but we won't if they don't. But,
I think there's something else. There was another reason why third party charge and not you're requesting.
Yeah, I'm not sure, but yeah.
The period of time is arbitrary, though. I think it's at the discretion of each department as to what constitutes an unreasonable amount of time.
It's normally published in their guidelines. Each department will have different ones.
Oh, okay.
And at the end of the day, as we'll see when we get to it, all of these issues are reviewable on first-tier merits review by the Information Commissioner, and then on second-tier merits review by the AAT. So it's not just an unreviewable policy and discretion by the department to deem whatever period they reckon's fair enough. At the end of the day, that can be reviewed.
And you've also got a right to complain under the Act as well.
Yeah, exactly. So it's, if you are determined enough, you can weave your way through the thickets and get something. It almost invariably won't be everything that you want, but you can get something usually if you're determined enough.
As was shown today with the release of the Attorney General's diary, which was finally released this morning. Yeah.
Oh, was it? I didn't know that. That
sort of slid through very quietly.
Well, it'll be less quiet very soon. But I don't know whether any of you have been following the saga of Attorney General Brandis's personal diary, which his Labor counterpart Mark Dreyfus has been pursuing for a year or more. And there was a federal court decision, I think, and even a full federal court decision holding over his objections that he was required to produce it. But despite that, he's delayed it for another few months. But apparently Matthew's just saying this morning he did actually produce it. I bet there's lots of redactions though.
Yeah, apparently there was the excuse that was put into it as well that some of the meetings were done at short notice, so weren't actually in the diary. But it goes the initial point was he didn't meet with legal aid groups before he did all the cuts to legal aid, which was the point they wanted to prove in the first place. But
right, yeah, that's very interesting. So this is very topical, isn't it? It's a very high profile example of the use of FOI to force the disclosure of information, even at a very high level, at the level of the Attorney General. So, but of course, most people are not going to have the patience and the resources and the legal expertise to achieve that. Whereas, of course, if you're a QC like Mark Dreyfus is, and you know, Shadow Attorney General, then you know, possibly you can.
And of course, the excuse was used that was the inordinate use of resources because, because the thing is that
Very large diary.
It was a diary, but the minister had to go and look at each single one and see if it was okay to release. And so it's a period of like 2 or 3 months. It would have been sort of reviewing every single meeting, and that's what I relied on, was an inordinate amount of resources, because the minister would have been required to vet every meeting.
But ultimately, they didn't succeed. Okay, well, how are we going? 1:39. Right, so we're doing quite well, really. The any applicable charge thing is interesting in the way it's used in relation to media. Even though they waive charges in Matthew's case because it's personal information, they typically do not waive it when it's media seeking FOI, seeking documents under FOI. And at the governance summit that we ran a few weeks ago, I don't know whether any of you followed it, but if you didn't, you really should have. Local media people indicated that their experience of FOI in the Northern Territory is that they're typically screwed for very large amounts of money for any FOI application. They were suggesting that it's not uncommon to get bills for $15,000 or $20,000 for an FOI application, which would deter most people, but apparently hasn't deterred the NT News, at least. They continue to seek them. Whether they make good use of the material once they get it is another question, but they certainly do pursue them. So yes, they can. Yeah, that's right. It's a time charge, you know. So if they make a reasonable estimate that it's going to take X number of hours for public servants to pore through every document and work out which one, you know, needs to be redacted and to what extent in the public interest, then they can charge for that amount of time.
And of course, they'll charge for the level of the person's also. It's not some AA1's going to be...
Yeah, sorry, we're getting some discussion that isn't on the microphones, but it's a bit inevitable. It also, as Matthew said, depends on the level of the person. So there's a higher hourly rate of charge if it's got to be reviewed by a senior public servant or the minister than it is if it just can be looked at by some lowly counter clerk or something. But typically it will have to be lowly counter clerk. Yes, I am. It's not. There's no Anti-Discrimination Act provision about calling counter clerks lowly. I don't think, as far as I know. It might be mean, but you know.
I wasn't going to say that.
But yeah. But I mean, typically because of the, you know, if there's any degree of sensitivity to it, and I mean, even to know whether there's any sensitivity to a document, arguably you've got to have a certain degree of seniority and knowledge and experience. So it would be very unlikely that they would delegate the complete task of deciding whether something should be released to a very lowly counter level public servant. So you know, there's almost inevitably going to be a mid-ranking person with a relatively good degree of experience who's the FOI person. Now, somebody in here, was it you, was telling us last week that typically NT departments only have, you know, 1 or 2 people as their FOI officers. But my microphone. Pass it over. See if we can. I mean, it's good for it to be reasonably intelligible to people listening to this later.
I'm aware of NT departments that have very few information resources.
Yeah, but do they, as far as you understand, refer more sensitive things to someone further up the totem pole?
Oh yeah, and rarely is the information officer an exception.
Oops. It's on? Yeah, good. If it's green and flashing, is it on now?
You gotta hold it in for like a second. Rarely.
No, it's still red.
Yeah, it's just that the key.
No, just so we can get it. We can get it going, I'm sure. Yeah, there you go.
Rarely is the information officer an exceptionally senior person, so they might compile a request, but the decision making sits above them.
Yeah, so basically they're the first port of call to sort of do the initial vetting, but
they might have
it's a matter of any possible
expertise,
yeah.
But they're not an exceptionally senior.
Yeah.
Some of them, and often if it's a very complicated request, they would have to second resources from elsewhere. There's no standing resources.
Yeah.
Yeah.
Yeah, Matthew's saying, which is why they can charge so much, because it's not their primary job, and therefore if they're being taken off their primary job to do this because it has any sensitivity at all, which they almost always will, then they can semi-legitimately say this is going to cost a lot of money, and therefore we're going to charge you a lot of money, I guess. You know, I mean, I can't think of any magical answers to that, but can you think of any answers that might improve that situation of how much they charge?
Depends on the department.
We can pass the thing.
Sam said it depends on the department.
That's all you wanted to say?
But
Well, hang on. Hang on. Can you pass the microphone to Sam, please? We do need to be disciplined about it, because 90% of the class does not attend, and therefore they're entitled to be able to listen to the lecture. They're entitled to complain if they can't.
Okay. Can you hear me?
Go on, carry on.
I was just saying, if it's a large department, then obviously it would warrant having people available for the tasks, or, you know, going on how many requests they have, because that would be documented. So, you know, they'd know that in the last year they had 1 request or 300 requests, and they can allocate the resources around that. But if it's a small department that hardly ever gets any requests, then you wouldn't have the staff for it.
Yeah, I think that's right.
Makes sense.
And there are, I mean, I would have thought that there are clearly some departments at state and territory level that predictably elicit the great majority of FOI requests. And that's basically, you know, health and police and corrections. So, and they are relatively large departments, and one would have thought that, you know, despite the fact that governments will no doubt protest to the contrary, it would not be unreasonable to have a reasonably senior officer who, for whom at least a significant part of their duties involves FOI stuff. They don't do that, though, I don't think. Carry on.
But FOI is reactive, and lessening the costs of FOI requires senior management to be proactive about record keeping.
Yeah.
And in my view, that's often the problem.
Yeah, exactly. Which of course is a significant part of the essay topic. The FOI of the 21st century stuff, talked about by Peter Timmins and by Transparency Australia and so on, involves advocating that all government departments and agencies ought to be required to digitise all of their files and resources, and to keep them in a proper, decent, searchable relational database with a good plain language search engine like Google, so that they don't, at least in terms of finding all relevant documents, they just don't have an excuse, because with a decent set of search terms, they will, with a click of a button, pull up all relevant documents. So that will at least cheapen it to some extent. You're still going to need to have somebody who looks through them all, reads them to see whether there's bits of it that need to be redacted or whatever for legitimate confidentiality exemption reasons. But at least you're going to save some of the cost. And as I say, at least if with the high volume departments you then have a reasonably senior officer whose job involves, albeit reactively, looking at these documents, then you know, you're going to have much lower costs, I think. Right. Next, sorry, I've forgotten you. I keep forgetting your name. Jahari. Right. Okay. Carry on.
Yeah, I was just about to say the same thing. I was reading the Open Government Australia. I think it was their I don't know whether it was a report or it was a plan. And then they were talking about databases, the lack of databases within departments and electronic databases. So
yeah, and there's really no excuse for it. I mean, they're not even very expensive these days, a decent relational database and a decent plain language, you know, like a Google. I mean, even Google, you can buy a commercial application of Google at a relatively inexpensive price, albeit that it's going to be all the data's going to be parked on an offshore database, which is inherently insecure, especially since the American government's got extraordinarily wide powers under the Patriot Act and other things to search things anyway, which would probably breach all sorts of provisions of Australian law. Although the trouble is, of course, the bastards can get it anyway, apparently, according to Mr. Snowden and so on. There's nothing they can't and don't access if they want to. But in theory, at least, actually, you know, knowingly entrusting everything to Google for a government is possibly something that would be difficult to defend, even though practically it makes no difference, one suspects.
But we've got laws in part here.
Microphone.
We've got laws that have passed, you know, getting access to that data. Anyway, was it the 2014 amendments of the Telecommunications Act, whatever it is, Amendment Act?
Sorry, what are you talking about? The stuff for journalists and so on, or the national security stuff?
The metadata retention laws.
Yeah, well, that's true.
So that's arbitrary, that argument now, anyway.
Well, but all that means is that the telecommunications providers are required to retain it. It doesn't of itself say anything about you know, who can access it and what decisions must or must not be made under FOI legislation. So they're separate points in that sense. It simply means that more of the data is retained for a longer period than would previously have been the case.
And I think a lot less of it requires warrants now, like before it was under stricter control. That's the way I understood the amendment, is that now there's a lot more freer access. I don't know, there was a change about the definition of public agencies or something.
Yeah,
anyway, sorry, getting off.
We don't want to look into that in great detail for this purpose. You probably did Les's privacy and FOI thing, so that's not something. I'm
not doing this one. I'm doing the other essay.
Yeah, well, that's okay. But yeah, there's obviously a lot more detail to this than we can go into in one lecture. You know, and certainly all that telecommunications, interception stuff and so on and data retention stuff is important. So is the telecommunications interception stuff that came into prominence in the Northern Territory over the last couple of weeks with I think Matt Cunningham from Sky News publishing secret notes by the charming Dylan Voller about his kill list of prison officers, you know, youth officers and fellow youth inmates who he'd kill if he had his opportunity, and the ways in which he would kill them. Well, no, I wasn't. I said I wasn't going to tell you about it, and that remains the case. Now that stuff, that's where there's legislation now too. There's amendments to both the Commonwealth Evidence Act and the Telecommunications Interception Act that provide at least a partial qualified privilege for journalists to not disclose their confidential sources. But it can be overridden. I mean, it's a balancing exercise as between the public interest in protecting a journalist's sources in order to, you know, enhance whistleblowing of illegal activities by governments, and on the other hand, the public interest in the fair conduct of legal proceedings, with all relevant material being before the court, which might include stuff that's been leaked to a journalist and the source. So So that's all interesting stuff as well, which we can't really go into in this course because we've only got one lecture on FOI and it's nearly half over. Philip Chamberlain.
Yeah, I was just going to add a comment to what you were saying previously about the fact of consolidating information on databases. That is actually something that practically can be a challenge for larger departments. So, for example, the department I work in, I was had previously worked in the fraud investigation area, and you have a discrete system which access to relies on having security clearances. So there'll be information on that which is discrete from just the normal departmental sort of database of information. You'll find in larger departments you'll have those sort of discrete accesses. Another example is social workers for some of the larger departments who, because of the sensitivity of the interactions they have separate records. That's not to say that those can't all be accessed via FOI, but it's just to say that you know, it's not as easy as having a central area for purposes of that discrete access that only certain officers are able to have get access to.
Yeah, look, I'm sure that's a very good point. And that having been said, though, I mean, sophisticated databases are able to have differential levels of permissions and different levels of searchability depending on your level of security access and so on. And if even that is regarded as problematic, and I'm not convinced that it would be, but even if there was, there would be, I would have thought, no problem with having a discrete database for the really sensitive stuff, but it is still a relational database that is searchable in a friendly manner, and therefore again can be searched, and at least the documents pulled up relatively easily, albeit that they then need to be carefully reviewed. I imagine if they are sensitive enough to be in that sort of a database anyway, there's a high probability that they would attract either one of the absolute exemptions that we're going to look at in the second half of the lecture, or at least a conditional exemption that means that almost by definition they're going to have to be looked at document by document. But at least you save that initial step of, you know, searching through the paper files in the basement, which is ridiculously and unnecessarily time-consuming. I'll go to Philip again and then to Amanda.
Yeah, typically how it works is you'll have a central FOI area, and that goes back to what someone was saying previously with a larger department via a smaller area. But what they will do, they will liaise with you in terms of information that they can't get access to that sits on in your system. And certainly that stuff now is all sort of scanned in and very easy to retrieve. But the way it used to work is you would get a notification from them, the FOI section, that Joe Bloggs had wanted access to all of his records, including details of relevant information from his investigation file. You would then go through that and view the request and provide a briefing back in terms of your recommendations about release or not based on any of the exemptions. The final decision, though, would sit with the FOI officer in that particular area.
Yeah, look, thanks for that. That's interesting. I take it it's a federal agency you're talking about rather than a Northern Territory one. Without saying what it was, yeah. Yeah, because I mean, at territory level, my general understanding is that they're, you know, the level of or universality of digitisation, particularly of archives, is much less complete. They may well do it mostly nowadays, and may have done so for the last, I don't know, 5 years, even 10 years, but they won't have done it going back beyond that, hardly ever, I suspect. And that's in part the rub of it, I suppose, that really for it to be useful, there's got to be sufficient resources directed to it so that archives are scanned in at least going back 10 years. You sort of suspect it's much longer than that. It's unlikely to be all that relevant, but it might be sometimes. But hang on. Jahari. Good. Most
internet services by government, like My Aged Care and most recently like the Carers Gateway, is all run by Health Direct anyway, so they privatise it out.
Yeah, that's right. Well, that's something that's worthwhile keeping in mind too, that when we're talking about FOI here, it's largely only relevant because of the way in which acts are phrased. It's largely only relevant where it continues to be done by government departments and agencies. If it's been outsourced and privatised, then by and large, FOI doesn't apply. So if you try and get FOI out of Transfield or whoever's now running the offshore detention centres, you've got Buckley's basically. Well, it's certainly under them, but the actual conduct of the detention centres is by private agencies, and so if you do an FOI, you might you'll force the Border Force to have a look at its files, but of course they'll claim national security on just about everything. It's an on-water matter. We're not going to tell you. Yeah, Matthew. Yeah.
If you want to find out about anything to do with one of the contracts that's been contracted out, you can't, because it's all, what is it?
It'll be commercial in confidence as well. Yeah.
You can't find out what the scope of that agreement is.
Yeah.
We had troubles we looked after immigration detention, trying to find out what scope was actually part of it, so then you could actually enforce what was supposed to be done. You couldn't find out, and they kept that very, very quiet.
Yeah, exactly. I might say, just as a hint, that's also part of the 21st century, FOI for a digital economy stuff that Transparency Australia advocates, is that there are, they argue, quite a lot of aspects of stuff that's supposedly commercial in confidence for which there's really no convincing excuse and which should be digitised and made available. And readily searchable even by commercial competitors, because really it's claiming commercial in confidence is just a nonsense excuse with a lot of it. If you contract with the government, in many respects, it should be made open and accountable. It shouldn't be secret, because it's taxpayers' money that's being used.
Ironically, one of the best ways we could find information around anything like that was actually through occupational health and safety reports, because there are things that had to be reported and had to be made public. So we're actually using RHNS reports to find out
backdoor means sort of thing. Yeah. Senate estimates was the other comment was made. Yeah. So in some respects there is more than one way to skin a cat, but you've got to be quite determined and resourceful to achieve it. And of course most people aren't and don't have the time. Amandeep, just your comment or question, and then we'll have the half-time break, I think.
Yeah, the only I was going to make was basically like, if in the ambulance service we can make patient healthcare records on the computers, there should be no excuse for not having actual electronic medical records. And when we're talking about the databases, like, I'm talking about a state agency, like, where different ranks, they got different levels of access. So, I mean, that excuse that, like, the significant resources in searches are wasted, that should not be an excuse anymore once we got into the whole electronic database systems.
Yeah, I think that's absolutely right. It's the older archive stuff. I mean, and there's some force in the argument that if you've got, especially if you're a larger department and you've only, you might have been doing this for 5 years or even 10 years, but to have to go back and archive, warehouses full of paper files would be a big job, and I guess it's a. Hang on. Mike,
To say, going back to the earlier point, if they had officers that were resourced for those departments, then guess what fun job they could be doing while they weren't processing.
Yeah, well, I mean, at the end of the day,
that's a legitimate job to do.
Yeah, at the end of the day, it depends on what priority you give to this. How important do you reckon that openness and transparency and accountability actually are? Are they worth spending the money on to pay people to digitise archives and so on? Because there are ways you can mechanise that to a very significant extent. I mean, for instance, Google has digitised millions and millions and millions of pages of library books, novels and non-fiction books and so on. They've stopped.
Kate says they've stopped.
They may have because of copyright reasons, but the government doesn't have that excuse.
Yes.
Digitising library books and things. Yeah, but they did do a hell of a lot. Yeah, it may be that they can know that they no longer they've discovered they don't make all that much money out of it, so they're not doing it anymore. But the fact is, they did in fact, even without any government resources, do millions and millions of pages of it. So to say that government can't do it is, gilding the lily, really, isn't it? Anyway, look, let's take the break now. We'll take a 7 or 8 minute break, and it's 2:04 by my clock. We'll try and resume at, say, 2:12 or 2:15 at the latest. So have a little break, and we'll see you in a few minutes. Okay, let's resume. This is the second part of Lecture 4, Topic 4, Week 4, Admin Law, Freedom of Information. So we've talked, we have resumed. I'll pass the mic over. Can we do a business baby again? We move on now from to the next slide, which goes on to exemption categories. Now, as a result of the 2010 amendments, the exemption categories are now split formally into two different categories. The two different categories always existed, they just weren't quite as clearly defined as they are now. There's Part 4, Division 2, which is exemptions, that is, if information is in one of these categories, then it's absolutely exempt. There's just no question about it. If it comes into the category, then you can't see it, and that's that. And Division 3, which is public interest conditional exemptions, where the document may or may not be exempt. Prima facie it is, but there's, again, a balancing exercise to be done. So if it's a conditional, and it's a bit like what I talked about before about disclosure of telecommunications information and journalists' privilege and so on, that there's a balancing exercise to be done if it's in Division 3, a balance between the public interest in disclosure and the public interest in non-disclosure. Prima facie, there's a public interest in disclosure of documents, and that's what all that Section 3 stuff says. Openness, accountability, transparency, all of those sorts of things. But there may be reasons why, in particular cases or particular classes of documents, that interest in disclosure is outweighed by the interest in confidentiality. I mean, one of the obvious things is your national security and criminal intelligence stuff, isn't there? The stuff we talked about last week in relation to Mr. Pocci and the Griffith Mafia conspiracy and the danger of ending up with, encased in concrete under the Tullamarine runway, where it's alleged Mr. Mackay ended up. But there's a lot of, less dramatic examples of that, where there may be all sorts of good reasons why particular documents or categories of documents in a particular case might not be there might not be a public interest in disclosure, or might only be a partial public interest in disclosure, which is why you end up with documents that are heavily redacted, because they're conditionally exempt, or they're not exempt, but there are particular parts of them where there may be a good reason for exempting them, and therefore they're partially redacted or almost entirely redacted in some cases. I think I may have mentioned in an earlier lecture there was a former and fairly unlamented Chief Minister of the Northern Territory, Shane Stone, whenever FOI came up, had a lovely time pulling out a document. He must have always kept it in his back pocket or something. He'd wave it and just, look, see, this is an FOI document that I got back at one stage, and all there is dear sir, and yours faithfully at the end. Everything in between is redacted, so what's the point of FOI? I don't want to tell you, they don't have to. And as I think I've also mentioned in a previous lecture, this relatively new series, Utopia, that's made by all of the DGen people like Rob Sitch and so on, has a wonderful episode about FOI where the public servants in the Futures Commission or whatever it is sit around for the entire episode dreaming up reasons to not disclose things, basically, only to be told at the end that the minister actually doesn't mind it all being disclosed anyway. So there you go. So let's move on. Oh, wait on. Well, I won't take you to the particular categories on a slide, but I will talk about them a bit because it's worth talking about them a bit without going to the actual sections of the Act itself. But the unconditional exemptions, that if they are these documents, then you just can't see them, is documents affecting national security, defence or international relations, cabinet documents, documents affecting enforcement of law and protection of public safety, documents to which specific secrecy provisions of enactments apply, documents subject to legal professional privilege, documents containing material obtained in confidence, where there's an express or necessarily implied promise of confidentiality, and that may pull in commercial in confidence, but there's a specific exemption for that. Documents disclosure of which would be contempt of Parliament or contempt of court. I mean, there's fairly obvious reasons for that. Documents disclosing trade secrets or commercially valuable information, so that's the commercial in confidence exemption, which, as I say, the Transparency Australia and the international transparency agreements and so on, and digital FOI of the 21st century suggests that perhaps there shouldn't be an absolute exemption for that. There may well be quite a lot of commercial information that should be made public. Electoral rolls and related documents is an interesting one as well. I remain to be convinced why electoral rolls need to be confidential, although I suppose they disclose people's personal addresses where if they are completely available to everybody, then it may be easy for violent husbands to track down their wives and the mafia to track down stool pigeons who they might like to blow away and those sorts of things.
There are political exemptions in the Privacy Act?
Yeah, there are. Well, that's a useful point for me to mention this too. At least with respect to personal information as opposed to information about other people, the Privacy Act may provide another way of getting access to your own information in order to correct errors in it. It doesn't so much provide an avenue to get information about broader government information. That's more an FOI matter. But there's substantial overlap between the Federal Privacy Act and FOI legislation. In the Northern Territory, I might say, most of that is you find all in the one Act. So the Territory's Information Act and Information Commissioner deal both with FOI stuff and privacy stuff under the one agency, which is quite efficient. It's a little bit archaic in some ways, where federally that you have a privacy commissioner and an information commissioner. I think it's the case now. I'm not absolutely certain. You might check, but I think that whoever's now the commissioner, which I think is a chap called Timothy Pilgrim, is now both the information commissioner and the privacy commissioner. I'm not absolutely certain of that, but I think it's true. Drago is saying you can go into an AEC office and view the electoral rolls. Yeah, well, I suppose that's right. So no.
You won't be able to view the entire electoral roll because you still have people who are enrolled discreetly. They don't have to give, they have a name, but they won't have an address.
Right. So it picks up people who need to keep it secret because of violent husbands or the mafia searching for them or whatever.
I find a lot of celebrities will actually enrol silently. So they'll be enrolled, but they don't have an address or anything sort of located on the roll.
Not one that's shown on the publicly available roll anyway. Yeah.
So the thing is, you can go in and search the rolls, but it won't have those on it.
Right. It might have their names, but not their addresses.
Have their names to say they're enrolled, but not their addresses.
Right. Thanks for that. I didn't know that. Philip, yes.
Yeah, just to add to that, you basically fill out a form and you have to make a declaration as to why you want your details taken off the public roll. It can be various occupational reasons, if you're a police officer or whatever, for the things that you suggested, if there's a possibility of people coming after you or whatever.
Or a criminal lawyer who you might have disgruntled clients who might want to you for whatever reason.
So it's all that sort of stuff. So perhaps the exemptions in the FOI sort of are meant to also protect those records from being accessed, albeit that they're not on the public roll. It might just be an extra backup that you can't seek to get them through FOI.
Yeah, I'm sure that's right. Okay, so let's move on now. There's Division 3, Public Interest Conditional Exemptions. Now they consist of sections 47, B, C, D, E, F, G, H, J, Commonwealth documents concerning Commonwealth-state relations, deliberative processes, that is internal working documents, and I'll come back to those, financial or property interests of the Commonwealth or Norfolk Island, certain operations of agencies, personal privacy, business, research, and the economy. Now, there's substantial overlap between some of those categories. And I'll come back to the internal working documents and so on a little bit later, but I'll just mention, I'll mention it now though, because it is the focus of Mr. Shergold's objections that of course form a part of the essay for some of you. Now, I'll just ask a question, and you might be particularly interested in this. I mean, it does seem to me that there's at least a certain amount of substance in what people like Shergold say. What do they say are the dangers or downsides, apart from wasting everybody's time, of allowing access to internal deliberative processes? It's partly what you said, frank and candid, but would you like to expand on that and then perhaps we'll go on from there? Just wait and I'll give it to Kate.
Oh, shit, Kate, that was on. You set it off.
Well, at least one of Peter Shergold's arguments, he makes a few, is that it inhibits public servants from giving free and frank advice, and the result is that robustly frank advice ceases to be documented in writing, and therefore there is less accountability
around that process. Well, there's two
but
stages.
It could actually reduce accountability rather than the opposite.
There's self-censorship by senior public servants in terms of what they're willing to commit in writing. And the secondary effect is they then give verbal advice that is more frank than the written advice that they provide, which has another accountability issue.
Yeah. Rather than trying to get it out for, I'll just tell you, I think, at least what my view about it is that what it said that goes on from there is that one of the major reasons why the public servants are reluctant to be frank and fearless in putting things in writing is that they're concerned that mostly the people who want access to it are either media or opposition politicians, and that, I mean, there's a fallacy in that it dismisses the possibility that there may be a public interest in the media and opposition politicians being the agents for disclosure, and that may be in the public interest. But it may well sometimes be the case that the media and opposition politicians are seeking the internal advice, especially where it's about possible policy options, more or less in an effort to make mischief and publish stories that say, oh look, they were going to do X. And because most people don't pay a lot of attention to these things, it's very easy to get a reaction from people saying, oh, how outrageous that Mr. Turnbull or Mr. whoever was looking at doing this. And there was a story to that effect published only a couple of days ago suggesting that the Turnbull government had reports about the possibilities and costs of abolishing, I've forgotten what it was exactly, but some category of benefits to aged pensioners. Now, and Turnbull came out immediately with a series of tweets and so on, denying that they'd ever seriously contemplated doing that, saying they absolutely weren't going to do that, and that they'd told the journalist who published the story that they absolutely weren't going to do it, and that the journalist published the story anyway. Now, all of that's probably true as far as it goes. And I suppose you can argue, well, that perhaps the people should be allowed to know that this option was considered. But the reality, necessarily, is that any government has to examine a wide range of options and work out what they're going to cost in order to work out what they should do. I mean, would you really argue that they should just sort of toss a coin or, treat policy as a piñata or something and burst it and pick up whichever lolly comes out, or pin them all onto a dartboard and adopt the one that the dart lands on or something? I mean, you would sort of rather hope that they might look at things a bit more systematically than that. And if what you've got is journalists who for gotcha reasons in order to ramp up a story that will sell lots more newspapers, or opposition politicians who've got a vested interest in painting the government as a bunch of heartless bastards who are going to defraud pensioners, are going to be able to have open slather access to all of these options papers that unavoidably canvass a wide range of options, most of which they're never going to look at seriously doing in a million years, then, I mean, that's highly problematic, it seems to me. Now, what the answer to it is, I'm not sure, and I don't think the answer is what Shergold says, namely which is just to abolish the internal working documents and perhaps make it an absolute exemption. I think that's essentially what he's saying. I think that's problematic, but there must be a better solution. Kate, have you got the microphone?
The solution is the public interest test. Really, you know, if you read some of the Information Commissioner's decisions about these deliberative documents, he is actually, or he's fairly sympathetic to genuine deliberative matter. But what is not possible is to exempt a class of document, and that's what Peter Shergold is calling for.
Yeah, it's got to be a fine-grained, you know, is this particular document one that could be used for mischievous purposes and easily misunderstood and misrepresented to the public?
Yeah. I'm not sure whether there's any cases where they may have argued that the potential for use for mischievous purposes as a public interest against disclosure, but it could carry some weight depending on the factual circumstances. Well, Peter Shergold's saying that if every deliberative document is subject to conditional exemptions, then you have to look at the public interest test on every document on every occasion. And he is basically arguing there are certain categories of deliberative documents. For example, incoming government briefs, that should just be a class of an exempt document. And what the Information Commissioner's decisions are saying, well, yeah, most of the content of these documents is deliberative, but that doesn't mean we should class the whole document as a deliberative document.
Yeah, that's fair enough. So that's the debate. And as I say, I can see some force in some of what Shergold's saying, and I don't have a magical answer to it, and I'm not sure. But equally, I'm not sure that the current situation is completely maintainable. It may be, for instance, that briefs to incoming governments might be wholly exempt, but not anything else, not anything that's an actual options paper that's delivered to a government that's actually going to have to make the decision, rather than stuff that's historical only. I don't know, but I think that's arguable. Go on. Yeah, it's a lot. It's right. You don't have to press anything. It is green, I think.
That one's a live issue. So the Hawke Review has one specific recommendation, and it's based on the Australians' FOI requests for the blue and red books, which are the incoming government briefs of the last governments. And basically, the Hawke Review has left open the recommendation that that should be a class of document that is exempt, whereas the series of Information Commissioner decisions are basically saying, no, these documents can contain substantial factual material, even though that material is substantially outweighed by the deliberative material. You shouldn't, there's no case to fully exempt the document as a whole. You would still have to look at it on a case-by-case basis.
Yeah, that's the argument in favour of leaving things as they now are. So I guess wrapping up all of this while we're on it, if you look at the notes study guide rather from page 12 through to nearly the end, really, page pretty much the whole lot of it, from page 12 to page 12 through to the end of page 15 anyway, deals with weighing the public interest in disclosure against the public interest in non-disclosure, and then the new situation or current situation since the 2010 amendment starts at page 14, and I actually reproduce in the notes the way they deal with it now is that the legislation itself in section 11 capital A lists discretionary factors in deciding whether to grant exemption quite expressly. So there's factors favouring access and irrelevant factors, and then guidelines. Now, factors favouring information are the obvious ones. Would it promote the objects of the Act, inform debate on a matter of public importance, promote effective oversight of public expenditure, allow a person to access his or her own personal information? Irrelevant factors requires me to just mention briefly the famous case Ree Howard and the Treasurer of the Commonwealth, which is, I think, around about 1985 or thereabouts, 86, somewhere there. Yeah, I'll get to it in a second. Where's my note of it? Anyway, it's a Ree Howard ground, blah blah blah. I must have mentioned it somewhere up further. Yeah, 1985. Ree Howard and the Treasurer of the Commonwealth. Now, at the time, as you know, 1985, early years of the Hawke Labor government. So the Howard was John Howard, who subsequently became Prime Minister, but at the time there was the, I don't think he was either the opposition leader or the opposition Treasury spokesperson anyway. And the Treasurer of the Commonwealth was Paul Keating. Now, Paul Keating managed to, or his lawyers, managed to persuade the AAT that in weighing the public interest in disclosure on documents that were conditionally exempt, the Act wasn't quite worded that way at the time, but that's effectively what it was. Documents that weren't absolutely exempt, but that might or might not be, depending on the public interest. But in weighing that public interest, it could weigh against disclosure. The factors that might weigh against disclosure included the seniority of the person who created, annotated or considered the information, i.e. Mr. Keating, very, very senior Treasurer of the Commonwealth, very senior person, can't possibly show it to you because he created it or annotated it. 2, the possibility that the threat of later disclosure might inhibit the frankness and candour of public servants' deliberations. Well, that's, Kate was talking about that before and we were discussing that at some length. And thirdly, the possibility that the public may not readily understand any tentative or optional quality of the information. Well, that's focusing on the point that I made a little bit after Kate, namely the risk that journalists or opposition politicians after a gotcha story might seize on one of many options that governments necessarily have to seek advice on in order to make a rational decision, and that the public might not readily understand that that's how governments must operate. Right? So all of those were considered to be relevant factors that might weigh in the exercise of the discretion about whether to disclose something. And subsequent decisions, both in the AAT and in federal court, looked with varying degrees of favour on at least some of those factors. But the 2010 amendments zapped most but not all of them. If you look at the irrelevant factors in subsection 4 of section 11A, you'll see that factors that are now deemed to be irrelevant and therefore that can't be allowed to weigh against disclosure include that access to the document could result in embarrassment to the government or cause a loss of confidence in the government. I'll ignore AA. That access to the document could result in any person misinterpreting or misunderstanding the document. So that's my argument, and Shergold's argument, which I nevertheless think have a certain amount of substance. And C, that the author of the document was or is of high seniority in the agency to which the request for access to the document was made. So again, that's the Paul Keating is terribly important argument. So they're not allowed to take that into account at all. D, that access to the document could result in confusion or unnecessary debate. Well, that's a further elucidation of the point that I made, and which is part of Shergold's argument. You'll note that one ground that was not zapped, the one Ree Howard ground that was not zapped and made irrelevant is the one about frankness and candour. Right? So they still can take into account the frankness and candour argument, you know, that it might inhibit public servants in giving frank and candid advice to their minister or to cabinet. Right? That still can be taken into account and be part of the weighing process. So to that extent, Shergold's argument isn't all that good, is it? Because that can be taken into account. It hasn't been rendered irrelevant. Shergold's argument is that it should go further than Rehoward and be completely exempt for pretty much all purposes. That there should never be a weighing exercise. I think that's pretty hard to support, frankly.
Good question.
Yes, Sam, microphone. It is red again, so you'll have to press it, but you're quite good at that.
With the frankness argument, like, aren't there exemptions to do with the third party anyway? So, like, you know, documents to do with investigations or reports that people had made, they would need consent in any case.
I'm only talking
so I don't really know what the argument is, because if those people are consenting...
No, well, the argument is that irrespective of whether there might be a commercial in confidence or a personal privacy argument or whatever, that nonetheless, in weighing up disclosure or non-disclosure, one may properly look at whether it might inhibit public servants' frankness and candour, or that it was created by a terribly, terribly senior person or whatever. Right? So that's documents where there's no privacy or commercial in confidence argument, there's no national security argument, there's no whatever argument, but nonetheless, we might have to just not show you anyway because it might embarrass the public servants or the minister or whatever. Right? That's the argument here. That's what Rehoward was about, and that's what the amendments to 11 capital A are about.
So he's saying despite those protections being there anyway, there still should be exemptions.
Yeah, well, because as I say, there may well be documents that don't attract any of those absolute exemptions, but which nonetheless should not be disclosed for other public interest reasons, e.g. frankness and candour.
Yeah, sorry, I know, that's the bit that I'm confused about, because if it's frankness and candour, then it's necessarily including the comments of a third party, which are protected. So I don't know. You're misunderstanding. I'll say it again. The frankness and candour is about inhibiting the frankness and candour of public servants who are not in a relevant sense third parties and whose confidentiality is not in question in the sense that the document is not about them, but that they might be inhibited because they might be embarrassed if their deliberations to the government are disclosed. Right? So it's a different point. Is it green?
There is the joy about, obviously, the frank and fearless advice that the public servant should give to a minister, because, unfortunately enough, if the government actually has control of all the information and what gets released out, they can tentatively release stuff that shows them favourably, but not the stuff that doesn't show them favourably.
Yeah, exactly.
And I've had situations where, in the past, confidential information between the Office of the Commissioner of Public Employment to the Minister was actually leaked to the media to put our members in a bad position during negotiations. And then we know the only place it could have come from was the Minister's office.
Whereas there was adverse stuff that they conveniently didn't leak.
Yeah, so it is that thing where sort of it can be used as a double-edged sword. If they're going to sort of release out information that can be damaging to the other side, there should be access to actually.
And that was actually, a significant part of the plot of that Utopia episode that I'm mentioning. That the minister eventually decided that the information was quite favourable to him, so if they didn't disclose it, he was going to leak it anyway, basically. So it all does achieve farcical dimensions sometimes, but Yeah, it's nonetheless important, and I can't think of an absolutely foolproof answer to it, albeit that I think your global answer is a pretty good one, namely that for most purposes anyway, the fact that there is a weighing exercise, and that weighing exercise of the competing public interests is subject to external merits review, firstly by an information commissioner, and then on second tier review by the AAT. So that's the other thing that you have to understand, and that really brings us quite close to the end of the lecture, and that is that although the department or agency makes the initial decision about what to release and what not to release and what to redact and not to redact, those decisions are subject to review, firstly by the Information Commissioner and then by the AAT. Now, in respect of absolutely exempt documents, the Division 1 and Division 2 documents, the extent of the Information Commissioners and AAT's ability to review is simply to look at the document for the purpose of assessing whether the document is genuinely a cabinet document or whatever. And if the answer is yes, it is, then the review role is at an end. There is no weighing exercise to be done. It is exempt, and that's that. But it's not enough for the department merely to claim it was a cabinet document or something. It has to actually be one. Now that having been said, I think there was an olden time dishonoured practice, which I'm not sure what the answer to it is, that they used to get big trolleys full of documents and mark them cabinet in confidence and wheel them into a cabinet meeting, and nobody would ever look at them, and then they'd be wheeled out again, and then when they got an FOI request, they'd be able to say, oh, cabinet document, absolutely exempt, bad luck, yes, Matthew.
There's a thing like that in the same thing done by the Working Dog Promotions of Highman, where they're taking children through a tour of Parliament House, and there's this woman just wheeling stuff in. What's that? Oh, they're cabinet documents now, and just wheeling them back out again.
Yeah, exactly. I don't know to what extent that's apocryphal, but it must have some degree of substance. Could you mark that up to Kate?
I have been instructed by the that an email completely unrelated to cabinet, but labelled cabinet in confidence.
Okay, well, I hope that's not getting on the tape, because you probably shouldn't be putting that on the tape, should you? Yeah, so look, I mean, it would be surprising if these sorts of abuses didn't happen to some extent, whether they happen in the sort of, on the sort of industrial scale that some of the stories say, like Matthew's one. I'm just not sure, frankly. And I wouldn't be totally surprised. So that's review. So these decisions are reviewable, and at least with the conditionally exempt documents, the weighing exercise will ultimately be done by the Information Commissioner and eventually the AAT if you go to second tier review. So you don't have to be satisfied with the dodgy weighing exercise that the department will inevitably do. But again, it requires you to have sufficient patience and determination to follow through to that extent. And a lot of people just don't. We're nearly there, luckily. The last thing is ministerial certificates. It used to be the case, up until the 2010 amendments, that there was that the minister could issue a ministerial certificate rendering any document or class of documents completely exempt, which might otherwise only have been conditionally exempt. That power was used, not all the time, but it was used. And of course, what it did was remove from the possibility of any form of merits review any documents that the minister just didn't want to be released. The mechanism of ministerial certificates was abolished by the 2010 amendment sponsored by Senator Faulkner. So it no longer exists at federal level, which is good. You know, in terms of openness and transparency, really the ministerial certificates mechanism was pretty outrageous and sometimes clearly abused. You might note, in terms of the territories model, that ministerial certificates still exist. Right? So they still existed when Claire Martin brought in the Act. You know, they were the norm in those days. But, you know, best practice has moved on. They've been abolished at Commonwealth level, and I think in some states, and I think there's a pretty powerful argument that they should be abolished in the Territory Information Act as well. So that would be part of a 21st century FOI regime. And the other major thing that's still in the Territory Act is that I'm pretty sure that all or most of the Ree Howard dodgy conditional exemption relevant matters are still there and have not been abolished, whereas at federal level, as a result of the Faulkner amendments, most of them have been abolished. So, you know, I think there's a good argument that the Territories Information Act model is now well below best practice and should be improved, and one would hope that the Gunner government may do so in the near future, although I've heard no announcements to the effect that they've got that in mind. So, look, I think that's pretty much your lot for today. I think we've covered pretty much everything I wanted to. There's more detail in the study guide, of course, and more detail still in the textbooks, but you can study that for yourselves, and if you're doing the essay, you're damn well going to have to, aren't you? So good luck with all of that, and we will see you next week, or if you're doing the 3 o'clock tutorial, we'll see you only a very few minutes. So let's take a 10-minute break, and then we'll start in the 3 o'clock shoot in the 3 o'clock tutorial room. So good afternoon and enjoy the rest of your week.